Okay, this is for voice, and it'll be at 210 words a minute. I am the witness.
I am attorney for the plaintiff, Mr. Hastings.
I am the court.
I am attorney for defense, Mr. Green.
Starts with a question by Mr. Hastings.
For the record, how about litigation files?
Probably half of those were in litigation at one stage or another.
Half to a third, from 33 to 50, then is that included in the 100 figure?
That's what you asked.
So you were handling about 100 files between April of 96?
Of claims?
I don't think that's what he has testified, claimed files.
We had other files involving underwriting matters labeled somewhat differently, but there were other files.
Do you know approximately how many underwriting files you were handling at that time?
At that time, probably close to as many as
About 100?
perhaps.
And that was just the ones that you were handling, not what the other attorneys were doing in the office?
I think that's right.
Did the other attorneys assist you at all in any of the claims files, which would represent this 100 figure?
Other than general conversation?
Because you are not an attorney that is admitted to practice in California, someone else in the office would have had to assist you in the litigation files. Is that correct?
No, these would be outside counsel with the exception of perhaps 3 cases of 5 or maybe 3 to 5 cases that Mr. Rusky was handling.
And in the outside counsel litigation cases, they would do most of the work and you would just kind of oversee what they were doing. Is that correct?
They would do all of the work.
Now, I believe you stated that when a file such as the one in this case was to be made, that you would do your part of the paperwork and then you would give the material to Cecilia Moody, who would do the actual preparation of the file. Is that correct?
She would type up the label, type up the claim form. If a claim form was generated in our office physically, assemble that file.
And then would she file the file away in a filing cabinet somewhere?
No, it would come back to me.
Back to your desk?
Yes.
And you would file it away?
Well, I would put it back for filing at such point as the file was dormant.
Who prepared some kind of a tickler system or calendar system that periodically can keep track of claims files, including litigation?
The manner in which the filing system was set up, it was possible to go to the file drawers and pick out all of the files that I was involved with simply by looking at the labels.
Because of a particular color or something label?
Yes.
But what would trigger you into action to say today, the 10th of January, to go pull a particular file?
What kind of file, Mr. Hastings?
A claim or litigation file.
Either a notation on my calendar or if I were to be reviewing the whole run of files, the date.
Who would be responsible for making the notation on your calendar?
I would.
If you forgot to put one down, is there any backup system for somebody else to check?
Yes, in that we were required to and are required to review reservice on a periodic basis. That would call for pulling each of the files.
You have to review all of the claims files on a 3-month or 6-month basis?
Yes.
So if you forgot to write something down on your calendar regarding a particular case, then someone in the next 3 months, you would be looking at that case anyway. Is that correct?
Yes.
Now, when material comes in, such as a letter from Mr. Reynolds or any other document pertaining to this file or any other claim or litigation file that you would have, or somehow it would get to your desk and you read it or did whatever had to be done, and then who was physically responsible or who was responsible for physically filing those documents in the proper files?
Subject to the form of the question, Your Honor, as being the last part.
Do you want to simplify it?
Ask him how it was refiled.
Mr. Collier, if a letter came in on a particular claim or litigation file, which was yours, and it got to your desk and you read it and then it was to be filed in the file, who was responsible for filing it? And what was the procedure?
I had a punch on the credenza behind my desk. I would punch and put them in the file myself.
You did that yourself? The
Yes.
secretaries didn't do that?
They may have once in a while, but I ordinarily did that myself.
Now, you were gone in the latter half of May to Alaska, is that correct?
No, sir.
When was it?
From March 15 to about March 29.
During that approximate 2-week period, who handled your files while you were gone?
Mr. Holtgren was in the office at that time. He would review any correspondence that came in that period too. Well, I suspect that he reviewed everything that came in.
After April the 6th, 1976, I believe you testified yesterday that your employment required you to take trips out of the Concord office to go to Monterey or Bakersfield or someplace else
I never said Monterey or Bakersfield because those were outside the territory.
in your entire territory, which, as I recall, went north to the Oregon line and south somewhere down by Visalia or someplace. And when you were going on those trips, how long were you out of the office approximately, if you can recall?
Usually not more than a day.
If you went as far as Eureka or Crescent City, would you be gone more than 1 day?
Probably overnight for Eureka. Why Eureka?
Eureka was as far north as you went?
Yes.
Well, you were out of the office during those times. Who would handle the correspondence.
Under those circumstances, the mail would be put on my desk.
Mr. Collier, yesterday I believe you testified that in spite of the language of your letter of April 6th, you had no intention to file an answer until you heard from Mr. Reynolds.
I'm going to object to the form of the question as being argumentative as to what the letter says. The letter speaks for itself, and it doesn't say that. It says that he expects, if you want, to ask him what he meant.
I will rephrase it, Your Honor.
He testified that the other than accumulating the information from the San Francisco office and perhaps from the Stockton office, he doesn't intend to do anything until he heard further from Mr. Reynolds. That's what he testified to. Now, Mr. Collier, why then did you put we intend to refer this matter shortly to outside counsel? Why did you put that?
Well, in retrospect, Your Honor, the language probably should have been stated a little more clearly.
Let me put it this way. At the time that you wrote this letter, was it your intention to refer to it outside counsel before you got a further notice of some kind from Mr. Reynolds?
No, and that's what I was trying to express in the letter. Apparently, I was somewhat inept with the language at that point.
See, if you just had the last part of the sentence, it would have said that you testified to. It said, we expect to have this file by accumulating the information of this file in such a condition shortly that an answer may be filed readily. But instead you started out, we expect to have this matter assigned to outside counsel shortly. Now, look back in your mind. Why did you say it that way, that we expect to have it assigned to outside counsel shortly?
Your Honor, on this one, I probably turned around. I wouldn't have turned around because of the location of the file. I probably picked up the dictation machine and simply said what I said.
But of course, then you signed the letter.
That's correct. My intention was that whether it was assigned to outside counsel immediately or not, it would be in such condition that when we heard from Mr. Reynolds, we would then be in a position to promptly answer and proceed. And whether it was assigned to outside counsel immediately or at the point where we heard from Mr. Reynolds seems to me to make not much difference. We had a lot of cases, many cases, in which the documents are handed to us or served on us, and in which after investigation into periods that we are secondary parties at best, or maybe even less than that.
Why didn't you just say that? I will accumulate the information from the various files, and when you notify me further, or when you notify me that you demand an answer or that you intend to take default, then I will get the answer.
I thought that's basically what I said, Your Honor.
Did you tell Mr. Reynolds that on the telephone before you dictated the letter?
What, counsel?
That you would wait further and for him until you would assign it to outside counsel to have an answer filed?
I don't recall. We discussed that specific, Mr. Hastings.
Did you tell Mr. Reynolds you were going to refer the matter to outside counsel?
I believe I told Mr. Reynolds that I was not admitted to practice in California and that we would have to assign it to outside counsel.
Did you indicate that in your letter when you signed it as a senior division counsel that you weren't admitted to practice in California?
No,
That indicates that you are an attorney, doesn't it, with that title?
I don't think that indicates that I am necessarily admitted to practice in California.
Mr. Collier, did you personally review that file every 3 months while you were in the Concord office?
Yes,
And your letter or copy of your letter was in that file all the time, is that correct?
yes,
And you saw that every time you looked at the file?
yes.
And you didn't send Mr. Reynolds another letter saying, I made a mistake in my April letter, what I would refer to as the outside counsel when you demand an answer?
I'm going to object to the form of the question, argumentative.
Did you ever send Mr. Reynolds another letter to clarify that one?
No, I never saw any reason to clarify that letter, Mr. Hastings, because I never ever heard from Mr. Reynolds.
Mr. Collier, isn't it true that when you have a case that is in litigation and TI is served, and to use your language, TI is kind of a secondary person in the thing and maybe really not legally responsible as far as plaintiff is concerned, that you either got a letter from the plaintiff's attorney or you send a letter saying we will do nothing further in the case until we hear from you?
Object to the form of the question being compound.
Objection.
Argumentative, you might ask what his procedure is.
Objection will be overruled. Repeat the question.
Ordinarily, I would call counsel for the plaintiff and follow up with a letter.
What type of language or similar language is it? Is that correct?
Well, the letter would reflect that what had taken place in the conversation. Skip down to 25. And let's read in 16s now. We'll slow down a tad. This is really hard. Okay, here we go. Where it is appropriate, yes, I do or did. In this instance, the discussion with Mr. Reynolds revealed that there was files in San Francisco involved. I had not seen those, but I wrote this letter immediately following the conversation. My review of the files in San Francisco led me to believe that it was a nuisance value case at best. I felt that the letter indicated.
Let me see now. Had you looked at those files before this April 6th letter?
I wasn't aware of those files before the April 6th letter.
So at the time of the April 6th letter, you didn't know whether this particular case fell within that category of more or less a nominal defendant, or not until you looked at the San Francisco file?
That's right.
You did have a copy of the summons and complaint at that time, didn't you, Mr. Collier, when you dictated that letter?
Yes.
So if upon examination of the San Francisco files, you had decided that there was a good chance of liability on the part of the TI and that it was one of the major defendants, then you would have referred it to outside counsel immediately?
Yes.
But after you looked at those files, you thought it was more or less a territory party?
That's correct, Your Honor.
Why didn't you write a letter to Mr. Reynolds, a letter to tell him that after you wrote him the first letter?
I could see no reason to write to Mr. Reynolds, stir things up. I felt that Mr. Reynolds certainly would be capable of running his own case, that he would know what his own views of the matter were, and that when he wanted an answer to the matter from TI, he would have to let us know.
Well, didn't you think Mr. Reynolds would rely on your letter of April 6th?
Mr. Hastings, I don't know that that letter calls for any reliance by Mr. Reynolds. To the contrary, that letter was intended and I think shows TI was relying upon him.
Well, I think certainly Mr. Reynolds would have a right of his interpretation of paragraph 2, which seems pretty clear on its face. Don't you agree with that?
Your Honor, I think it calls for speculation.
Objection will be sustained.
Do you think Mr. Reynolds expected this matter to be referred to outside counsel?
Your Honor, again, I think it calls for speculation what Mr. Reynolds could have expected TI to do.
Objection will be sustained.
That's all I had at this time, Your Honor.
I wonder if Mr. Collier, could you do it right now, of course, but I wonder if you could prepare it in the next week or so and put it in
Next
writing?
page.
Next.
Trying to make it so the court doesn't have to say so much because I don't want you to lose your voice
Right.
before it takes.
Okay.
Let's skip to page 103 and we'll finish up here. 103, line 5 with Mr. Green. That wasn't territory, that was tertiary. And I'm gonna have to look that up after we get done.
Yeah, I
I'm
said that
unsure
wrong.
of the meaning. Okay, so Mr. Green, here we go, page 103.
Third choice.
For the record, just so the record is clear, my memory for everything that is said in the case is not the best at times. Did you, sir, ever receive on your desk or any time before this proceeding started a letter from Mr. Reynolds dated, I think the first one is April 27th, advising you of depositions?
No,
There was another letter following that, which I believe was maybe 2 weeks later, wherein Mr. Reynolds said he would take a default of TI. Did you ever receive that letter?
no, sir.
With respect to those two letters, at any time before, at any time until today, has anyone at TI ever advised you that they received those letters in the normal course of events?
No,
The best of your knowledge is the first time that anyone at TI ever saw those letters when they were taken from the file of the Superior Court in this county at the commencement of this motion to set aside the default?
that's my best knowledge.
Now, sir, with respect to the knowledge of entry of default, which I believe the date is somewhere in the first week or so of June of 1970, is your testimony the same with respect to that document as it has been to the two previous letters?
Yes,
As I understand your testimony, you were away in Alaska at some period of time that would correspond with the time that the summons was served.
that's correct.
So you weren't actually in the Concord office the day that Mr. Hart received the document,
That's correct.
and you returned from Alaska on what date, sir?
I was back in the office on the 29th.
That would be the 29th of March?
Yes,
Do you remember what day it was? Was that a Monday?
that was a Monday.
Did you have work stacked up for you when you got back?
A substantial amount.
And did you, when you called Mr. Reynolds, was that the same day that you had reviewed for the first time the file in this matter?
Probably not. I would ordinarily skim through the stack of material on my desk. I believe I called him on the 6th of April. Frankly, I don't recall what went on between the 29th of March and the 6th of April with regard to this particular file.
And the day you wrote the letter was the day you called him?
Yes,
When you called him, did you have the San Francisco file?
no.
Did you have the San Joaquin County file or the Stockton file?
I had discussed it with Mr. Hart. I believe I discussed it with Mr. Hart by phone.
At the time that you called Mr. Reynolds, did you have at that time any evaluation of the case from Mr. Hart?
Yes,
And was that contained in the file?
there was a loss report that had been prepared by, or a claim report that had been prepared by Dr. or Mr. Haight together with our discussion. And there was another memo from him which was addressed to Julian Holtgren, which I believe accompanied the documents that he sent over.
Is that often in the form of an inter-office communication?
Yes,
That normally is a communication between your manager and council?
yes,
And is this the standard procedure of TI?
yes.
I'm going to hand you an inter-office communication apparently initialed by Jim, dated March 17th, 1976.
I would like to take a look at that.
I will have it marked before I ask any questions. Is that any communication?
Yes.
Your Honor, I would like this marked as defendant's next in order.
Defendant's Exhibit D.
I see that there's a stamp on the back of Exhibit D. Could you tell His Honor what that stamp indicates?
The stamp is a receipt date stamp for title insurance and trust company. It appears to me to be the same stamp which was used in the Concord office.
What date is on that stamp?
March 24 shows a receipt at 8.
Incidentally, at the top of that letter, what does it say? In re what?
The subject is claim number 76-0002.
Can you explain to His Honor, if you can, whose claim number that was?
Well, that would be the San Joaquin County component claim number assigned by Title Insurance and Trust.
In San Joaquin County?
And the San Joaquin County operation is a separate component, has its own component number, and matters are computerized on the basis of the component number and the claim number for that particular component. And this instance would indicate that was the second claim which had occurred that year.
Now, incidentally, in your office, do you know at Concord, was that file, was that just by some sort of a number? It didn't have a name on it?
I believe that the claim would have an initial C, which would stand for Central Division, Central California Division. There would be a name and a number on it.
Do you have it here?
We have the file, Your Honor.
What is the title, year on it or something?
I want to put it back together. It's not now in the same order.
I want to look at the whole thing. I want to look at the manila folder.
Just the tab, Your Honor?
The tab, yes. It's just by number. Maybe that explains the whole, maybe the letter got in the wrong number or file or something.
I put the file together and I am handing to the court the jacket which has a pink tab on it, which the court can read into the record.
It has the name of the case here, Cinemark International versus Marine Park, and it has C numbers off to the side.
Yes.
No, that would be the office file number. What is it, 1765 before that office file number?
That would be that year, which is typed on correspondences with the C 1765, which was put on in pen in addition to the label.
That's a claim number?
File number.
File number in Concord?
Yes.
And to clarify once more, then the number on the Hart memorandum is the claim number,
That's correct.
and that designates where it comes from and the year and the number of claim and sequence?
This claim number does not designate where it came from, but that would be understood from the memo itself.
Now, when the IBM or computer part of this thing you have been testifying to, which number does it carry?
It would carry the county component number, which does not appear on Exhibit D, and it would also carry the claim number. In addition to that, it would carry the county file number from which the claim arose.
And did you review this defendant's Exhibit D before calling Mr. Reynolds?
Yes.
Now, sir, besides the summons and complaint, did you receive from Mr. Hart this computer document you are talking about?
Yes. Okay, this is be 5 minutes and we're going to read it in 15, so this will be at 200. I am the witness.
I am attorney for the plaintiff, Mr. Williamson.
I am the court.
I am attorney for defense, Mr. Dawson.
Oh, she's got it.
Okay, this is warm up. 5 minutes.
And let's speak.
Begins with the court reading in 15s.
Okay, and it's the court for the record. The case of the people against Douglas Arthur Mozingo, defendants present with his attorneys. The district attorney is also present. As I recall, gentlemen, today we are going to argue the motion to exclude the statement.
That's correct, Your Honor. We were going to start with some evidence concerning the statement.
Yes. And
At this time, Your Honor.
Mr. Dawson, you indicated to me you wish to make a motion.
At this time, Your Honor, we would make a motion to close the hearing to the public and press pursuant to Allagrazie, Allaegrazza versus Superior Court. It's cited in our memorandum of points and authorities in support of the motion to exclude the statement.
All right, you did, of course, ahead of time tell me you were going to make this motion, and I appreciate that. The citation to Alagraza against Superior Court located at 47 Cal App 3rd at 9. Well, it's in 948, I believe. It's in the 47 Cal App 3rd. I read the case, and it does say in this type of motion, you are entitled to a hearing in camera out of the presence of all spectators. Your motion is granted. I do note we have some spectators here, and I have just granted a motion that the hearing I'm going to have now upon motion before me must be heard in camera, which means without any spectators. So unfortunately, I'm going to have to ask you to leave, so you can go find another courtroom.
For the record, I have asked the bailiff to post a sign, and he is now preparing a sign that the proceedings be closed and that be put on the front door so that we do not have any interruptions and have to stop the tape in the proceedings so we can have someone exit.
I do note there is still one person in the courtroom. Is this somebody from one of your offices?
That's a witness that is going to be testifying in this particular matter, Your Honor.
Okay, that's correct. I remember. All right, she testified before. All right. Are we ready to proceed then at this time?
Yes, I am, Your Honor.
All right, this is then, actually, we're going out of order. This will be relevant to the notice of motion to exclude defendant's statement, referring to a statement made to Sacramento Police Detective Crump and Wagner on October 4, 1998. Rather than going forward first with the people who made the motion, the defense, you're going to go forward with some of your evidence as to that. Is that correct?
Yes,
Of the taking of the statement.
that is exactly right. And the statement itself, Your Honor.
And the statement itself. There any objection to using this procedure from counsel?
None, Your Honor.
All right, then you may call your witness.
Thank you. At this time, the people call Detective Flossie Crump.
I think she's already been sworn in this matter, having testified before, and so you're still under oath, Detective Crump?
Okay.
Detective Crump, can you tell us where you work, please?
Sacramento City Police Department,
What unit are you presently assigned to within the police department?
sexual assault and child abuse.
I'd like to direct your attention back in time to October of 1998. Do you have that period of time in mind?
Yes, I do.
What unit were you assigned to within the police department during October of 98?
A homicide assaults detail.
Specifically, I'd like to direct your attention to October 4th, 1998, shortly after 10 o'clock in the morning. Did you have occasion on October 4th, 1998, shortly after 10, to go to the Sacramento Medical Center here in Sacramento County?
Yes, I did.
Can you tell us why you went to the Sacramento Medical Center on that date and at that time?
We had a suspect who was in the detention ward at the hospital, and my purpose was to take a statement from him with regard to the incident that just recently occurred.
All right. Was this referring to the incident involving some shootings at the Mother Lode Bar on October 1st, 1998?
That's correct.
Was the suspect, had he been arrested as of October 4th, 1998?
Yes, he had.
When had that suspect been arrested?
That was on October 2nd of the same year.
Were you one of the arresting officers?
Yes, I was.
The person that you had arrested with respect to the shootings, is he in court today?
Yes, he is.
Could you describe what he was wearing for the record, please?
He's wearing a black t-shirt with gray sleeves of another shirt extending from.
We'll stipulate there's only one such person in the courtroom who is the defendant, Your Honor.
Very well.
Upon your arrival at the medical center, did you have contact with Mr. Mozingo?
Yes, I did.
Where was Mr. Mozingo when you had contact with him?
He was in one of the hospital beds in the detention ward.
Who else, if anybody, was with you when you initially had contact with Mr. Mozingo?
Detective Wagner.
And when you first encountered Mr. Mozingo, was he awake, asleep? Could you describe his appearance to us, please?
I believe he was asleep.
Did you have to awaken him?
Yes, we did.
Now, did you have a tape recorder with you when you contacted Mr. Mozingo on October 4th?
Yes, I did.
And did you activate that tape recorder for purposes of recording your contact with Mr. Mozingo on October 4th?
Yes, I did.
Did you bring with you to court today the tape recording of your contact with Mr. Mozingo, which occurred on October 4th?
Yes, I did. Okay, that's the end of our warm-up tape.